Jonathan Sanders with LSU. Valencia Jones with LSU. And Stephanie, I think it's Rempa with LSU. And I'm sure their legal counsel is coming with them, so we'll need that side chair.
I'll just stay in the back.
Okay, you sure? Okay. One thing. I think one, Mrs. Sargent Arms, is we can pull up that third chair so that she can be close to the mic if she needs to testify. She's with this panel. That'll be work. She can sit there and that'll work. Thank you. Welcome to the committee.
Thank you, Senator.
Do you all have a presentation?
I'm sorry, are you waiting for a presentation for me? Oh, I wasn't aware.
Your name for the record, and your position at LSU.
Sarp Jones. I'm a member of the LSU Board of Supervisors.
Okay, thank you.
Jonathan Sanders, Associate Dean and Director of Student Advocacy and Accountability.
Okay.
I'm Stephanie Remp, and an Executive Associate Athletic Director.
Okay, thank you. While we're waiting on members to get in queue, I'll ask the same question of each person. You will start with the board member. You're a member of the board, and how long have you been on the board?
I was appointed to the board on August the 29th of 2016.
Okay, and so you are one of the board members that was there when some of these incidents took place.
Yes.
Okay, was the board or you ever made aware of any of these incidents?
I was made aware of an incident during would you mind if I kind of give you some background?
Sure, go ahead. Mm-hmm.
Thank you so much. And before I begin, just thank you all so much for having me today. I appreciate the opportunity to speak before this honorable body of women legislators. The work that you all are doing here is extremely important. Not only to you, I assure you that it is extremely important to me as a mother, a citizen of Louisiana, and of course, as a member of the LSU Board of Supervisors. So I want you to understand that this is extremely, extremely important to me. And I will do my best to make sure that we never revisit these issues again, that these things never occur again. I know that you guys are receiving a lot of information on trying to understand what we do. Mm-hmm. President Henderson just kind of gave you an explanation, but let me explain, if you will allow me to explain my understanding of what we do as a LSU Board of Supervisors and how we work. So we are on the policy and governance. We work on the policy and governance as well. So we are not involved in the day-to-day operations at LSU. So oftentimes all the time, anytime that we receive information, it's based on the information that someone decided to share with us, right? So we have no day-to-day knowledge of what's happening. So as it relates to the question you asked me, I was, as a member of the athletics committee, as the chair of the athletics committee, told that there would be an investigation into an issue involving an issue where something was it was found that Verge Osbury had received a text message from a student athlete, and that was being investigated. So that was what I was told.
What year was that?
I can't be sure what year that was, but I can tell you I was the chair of athletics at the time.
So when you were the chair of athletics committee, you were informed of investigations surrounding the athletic department, but not the details of it.
I was not informed of all issues, I was informed about one that I
How
can
did they
recall.
cherry pick what you were informed about?
That I cannot tell you, but that is oftentimes what happens, is that information that is shared is sometimes cherry picked.
Okay. Okay, so let's talk about your role as chair of the athletics committee. Should when there was serious issues that came up with the athletics department in the area of sexual harassment and misconduct of a coach or a player, should you have been apprised of that?
I'm not really sure of the answer to that because, again, we are on a policy and governance level, so the only person who actually reports to us is the president. So, Winston, can you help me as far as what?
And I'm
should
asking
happen
because
there?
everyone keeps saying policy and governance, but as I deep dive into this, governance of the athletic department should be in the jurisdiction of the athletic committee. And I think what is included in governance is if we have issues with reports, right? So whether it's governance stop with the athletic committee or whether it start, because I know we shouldn't just be over the money. I know we shouldn't just be looking at the budget or the contracts, right? Okay, more detail. When a coach is hired or when a search committee starts, are you made aware of that?
Sometimes.
We are not part of that process, so at some point we know.
But you have to approve the contract.
We approve the contracts.
Does
But
that contract
the legwork
come?
is done.
Yeah, I understand that.
Yeah.
But you approve the contract. Does that contract for that employee, that coach, come to the athletic committee first, or does it come to the full board?
It comes to the athletic committee. We generally meet all together. The entire board is at the committee meeting.
Right, but it comes to the athletic committee first,
Yes.
and then it passes out of, it's heard before the athletic committee, and at some point it's sent to the full board for a vote.
Well, that all basically happens at the same time. So the athletic committee meeting would take place at some point during the meeting. We discuss it. It's in an open forum like this.
Right.
And the whole board is present during that time.
What she's trying to explain is committee meetings occur on the same day as the board meeting, but the committee meetings occur in the morning, and then the board meeting occurs.
So that's what I'm saying. There's an athletic committee
Yes.
meeting, and then the board. Is the contract for an employee required a coach, athletic director, required to pass the athletic committee before being passed on to the entire board?
Yes.
Okay. So let's say we hire, LSU hires someone in the athletic department. I understand you all don't do the lead work. Does that recommendation for a hire, do those hires have to be approved by the board? I'm trying to figure out what has to be approved by the board, what employees have to be approved and what don't. You know, I'm trying to kind of.
I understand. I do. It's a difficult, it's really difficult to understand. So we approve it, but it's not like we are part of the process. We don't interview anybody. We don't actually, we take the recommendation of the athletic department. So when the athletic department makes a recommendation that they want to hire someone to be a coach, we accept that recommendation because.
So, Senator Jackson,
Right.
to provide you some background that the lawyer would know that she wouldn't know.
Okay, good.
Coaches contracts in excess of $250,000 require board approval.
Okay.
Coaches without contracts whose salaries are less than $250,000 can be approved by the president.
Okay. So if an athletic employee is hired, that doesn't come before the board for approval. Only if the contract is above $250,000. Let's say if you hire someone with the athletic department that's not a coach, those don't have to be approved by the board?
There's a salary threshold for regular staff employees, so if it's below the salary threshold, no, it would not be approved by the board.
Okay, I get it. And that's what I'm trying to see, Attorney DeQueer. Where is the governance of the athletic committee? Like, where does it start and where does it end? I keep hearing we just govern, we just govern. I keep thinking in my mind, sexual harassment suits, problems with the department, repetitive sexual harassment suits, is governing. Why is that being excluded from governing?
I wouldn't say it's being excluded. What I'm saying is that we don't necessarily, most of the things we're hearing is news to us as well.
So you're saying that the board would not have been prohibited from receiving that information as long as it didn't disclose the identity of the students during the investigation, but it was only one given to you in your entire time in the board. Like, how long did you serve as athletic committee chair?
2 years.
In your 2 years,
That's the only incidents I had ever
heard of. Okay.
been told that there was an investigation about.
And so, what 2 years did you serve as athletic committee chair?
I think 2017 and 18, and then 18 and 19.
Okay. And so when you guys were apprised of this incident, was the resolution or the investigation or the details of our conclusion of the investigation, probably the best way to put it, was that reported back to you?
It was not.
You guys didn't think to ask?
Yes, and we continue to get, and it's ongoing kinds of answers.
And
Inconclusive kinds of
you-
answers.
So as the board, as the athletic committee, you were apprised of an incident of a woman being beat, supposedly, allegedly, let's say that because I want to be fair, allegedly. And the board never called in anyone that was investigating it to get a report or a conclusion of what happened?
We did not.
Okay. Did you all report it to the full board?
I don't know if it was or not. I'm not sure.
Yeah. So you were there when the buyout of Les Miles' contract happened?
I had just been appointed
Okay, so you had just been appointed.
in August.
So you all were aware then, but no, when the buyout happened, you hadn't been made aware of any incidents with Les Miles.
No, I had not.
And so the Taylor Porter report that was sent to, when was that report sent, attorney?
May of 2013.
Okay, so basically you come in as a new board member. Were you made aware as a athletic committee at the time that Les Miles couldn't visit with females alone, that he had a school-issued cell phone and that was the only way he could communicate with anyone at LSU, that if he walked in a room and he was the only male in there with a female, he had to leave?
I had no knowledge of that.
And so you served how long with Les Miles under these restrictions and the board wasn't made aware?
Only like 3 weeks, maybe a month.
But don't you think that you all should have been told that, because that's a part of governance if you have an employee on campus that can't be around female employees?
Absolutely.
Okay.
A person who cannot be, yes, absolutely. That should have been shared. That's not okay.
Now, this is a big question for me. We know some board members knew, but you're new. The buyout comes. When you all were discussing whether to, let's say, vote on the buyout or whether to fire him for cause, was any of the allegations that we currently are aware of with Les Miles brought to your attention? Were you informed of them? Did LSU or anyone there give you a report of it so that you could make a firm decision on whether or not to pay him $1.5 million after he had harassed our girls?
No, ma'am, I did not receive any of that information.
So,
Nor was I part of any discussion like that.
so basically, you went off of a no-cause termination.
Yes, ma'am. That's correct.
Okay. Did you guys have an opportunity, because of course you had to vote on a $1.5 million buyout. Did you have an opportunity to ask questions of his performance?
I'm sorry. I don't know. Did we actually have to vote on whether
You
or
didn't?
not that we would?
I'm not sure. I don't know if they had to vote, but I do know a termination is affected by the athletic director and the president, so that might not have had to go to the board.
Yeah, I'm not sure we voted on that. I think it was just a decision made by the athletic director and
But I thought that anything over $250,000 required board approval.
His contract would have already been approved. This
Right.
would just be terminating it.
So the president and the athletic director by themselves the board has to approve the contract. But the athletic director and the president can pay out $1.5 million without board approval?
I'd have to go look.
Well, I really want to know before the end of
Yeah.
this committee. Let me tell you something. I've never seen an operation where a board who has to approve the hiring doesn't get to dictate or vote on whether someone, and it should never be in Louisiana, spends $1.5 million on a person. And I'm not being derogatory toward you, but that is very concerning that we would have paid anyone $1.5 million and the board that governs the school wouldn't have had some say in approving that $1.5 million payout.
We'd have to pull the minutes from 2013.
I
to see
think
if
we
that
have
went to the
some
board.
minutes. When did that happen? Because I'm looking at 2013 minutes.
2016.
That would
It
have been
be-
September of 2016.
Okay, I'm going to be looking. And because that's my concern, though, these are all 2013. Yeah, that's my question. My question, if you can pull it, is what had to happen for Les Miles to receive $1.5 million and get terminated for no cause when obviously who was the president then? I guess, did the new president know?
King Alexander was the president at that time.
Right. And so and he's not here to answer. I hope he comes to the next meeting. And I can't blame you for that in the sense of if you didn't vote for it, but I think we're going to wait on that answer. But I am very concerned about why I keep hearing today that governance does not include sexual harassment or being made privy to sexual harassment allegations, especially those that are serious in nature.
Right. I'm not, I don't mean to say that it doesn't include that, because it most certainly does. Something like that certainly rises to a level that we should know about it.
But I am shocked, and I want to be very transparent over the fact that there was an allegation of a young girl being beat, and that LSU may have dropped the ball on it. And the board at the time, who was made aware of it, didn't press for a conclusion of the matter in a report. That is on us. And when we get that, the committee wants to know, Attorney DeQueer, when you get those answers, if the board doesn't have to approve the buyout, will that policy change? Because I think that perpetuates a cover-up. When an athletic department can decide whether a person is terminated for cause or without cause and pay them millions of dollars, and the board doesn't receive a report on it, I really think that it should have stopped there. When they got ready to fire Les Miles, the board should have been made aware of his entire employment file, and I think that might be something we need to put in law. You know, you're getting ready to fire someone. Why isn't the board made privy to his entire employment file so you can determine whether or not this person deserves millions of our dollars? And I know you're still looking, and so that is my concern. That is a major concern, and we're going to be going back to that. But I want to say this on the record. There's not a woman sitting on this committee that would have heard of a domestic violence incident in this capital that wouldn't have pressed and demanded a report. And that's just being very honest with everyone sitting here. We have to be a little bit more diligent. And I understand the restraints that the board is under. You're not the president, you're not this. But I think at some point there needs to be something put in policy. That Title IX, and have we put that in policy? I hadn't read the whole thing. That when Title IX reports are given, that the board gets a monthly update, even if they don't get details. These are the number of Title IX reports. These are the amount of Title IX reports that are in athletics.
That is
It's
something
this
that we have
department.
requested.
Right, and that should happen monthly. That really should, because I think in governing, you need that information.
Mm-hmm.
You know, and have you found that part?
His contract is about 3 different documents, all different amendments signed in different years. And I'm pretty good, but I'm trying to go through this as fast
No, I
as
understand.
can.
My question is the 2018. We did a buyout.
But but the amendments don't all have separate termination clauses, so you have to cross-reference them.
Right, but I guess what I'm more concerned about is the year of the buyout. Whenever this board paid out, because it's the board, it's the school, $1.5 million, did the board who had been appointed to govern the university? And do you have the terms of the buyout as well? But I just don't understand how $1.5 million slipped from our university and our board wasn't included. Because I think that was a massive cover-up. If you want to uncover something, say, oh, we're buying out, you want to pay him $1.5 million, let's see his entire employment file. I think at that point, the board would have been made privy to everything that was going on, right? Absolutely. And as a new board member, you would have had the information and you could have corrected this moving forward. But I think that all of us think that if somebody's paid out $1.5 million because, you know, without cause, you think as a new board member, he just didn't perform well on the football field, our team is not performing well, we're buying out his contract. That's what we assume, right? We're not having such a good season. And so that bothers me more as we continue to talk about this, is that it's like new board members are coming on and they're still not being given the information. And Representative Davis is saying something that's true, that you have to make sure those employment files have everything in about the investigation. So I want to make sure moving forward, we do, that if someone is investigated, even if they're proven innocent, that should go in the employment file so people can know they're innocent. Mm-hmm. And that's one way. But I mean, I can imagine finding out through a report. I've been on the board 2 or 3 years, that in my first month, like I guess you've had to find out that we paid someone $1.5 million who was harassing our girls.
Absolutely.
You know, that's not the way we handle business. It's shocking. Senator Mizell.
Thank you, Madam Acting Chair. I appreciate, I know you weren't here the last meeting, and you're picking up after a long day. I don't know if you all were in receipt of a statement that we received from former Supervisor Stanley Jacobs. We can make it available to you. It was something that came to the members just before the meeting. And I'm not going to read you the whole thing, but I think since you're on the board now, these are the areas of concern to me, because I mean, this is, to me, the whole point in our having a meeting, okay? One comment he makes is, a determination was made by either Dr. Jenkins, president of the system, or Taylor Porter, that only the 3 of us, Bobby Yarborough, Hank Danos, and myself, would be in the know regarding this investigation. And this is referring to the Miles situation. The reason being that the female student under no circumstances wanted her name revealed, and we felt it vital to protect her privacy. Obviously, we were concerned about privacy for Coach Miles, as well, as we did not know at that point if the allegations were true or not. So there you go. Further on, he says, at some point in time, I requested that Les Miles be brought to our group. I wanted to present the allegations to him and gauge his response to them, but we were advised that this was not appropriate. And I think that, you know, when we've been saying that about getting to the point of it, who would have said, who would have been the advisor? Was that I know you weren't there, Attorney DeQueer, but that's the concern to me. This board member obviously wanted to get a clear picture of what was going on, and he was told it would not be appropriate. And that is just a root of the problem, is that over and over, I've been seeing like 6 steps of an opportunity to step in and be honest. And every time somebody, and I don't know who this was, okay, but then he says several things, but this is his closing line. In closing, at no time during our investigation of Coach Miles did Joe leave a request to us that he be terminated. Any emails that were sent to King Alexander or Dr. Jenkins were done after the fact. In the course of him retelling the what we've all talked about with what happened with Coach Miles. And this is a broader question to me because I've heard references to it several times today. They required him to use his LSU issued cell phone. What other cell phones are people using, and why, if they've got an LSU cell phone, would they have to put something on another cell phone?
I cannot answer that question for you. I don't know anything about cell phones that are used by LSU employees.
Could you help us, Attorney DeQueer?
Yeah, my understanding, and Stephanie can add to this, is that coaches have to log certain phone calls because of the restrictions on communications
On the recruiting.
with recruits.
Right.
So they prefer coaches to use school issue cell phones because the bills come to the school, and it makes logging the phone calls for recruiting compliance easier. In my review of the Les Miles investigation, he kept another cell phone because he knew the school would, ostensibly because he knew the school would be looking at the calls on one cell phone, and so to communicate with a student, he would use this other cell phone. And so they mandated that he only use his school cell phone.
So it
That's the only, I mean, this is my presumption having gone through this.
yeah. But you know, and in all fairness, I've heard references all day in the last meeting too about, I know these people, they're good people. Everybody thought Les Miles was just this crazy fella eating grass. They had no idea that this kind of stuff was going on. So we throw the term good fellow around, and then we give them no oversight, and we say, just use your LSU issued phone, you'll be fine. When he's doing these clandestine things, and by absence of oversight, we're allowing it to happen. So I really would like to know more about the whole cell phone situation, but I appreciate Supervisor Jacobs being open and frank enough to send us something that basically included him in a situation that we've all had questions about. So I thought that was helpful. Senator, I have a question, but it's for later from somebody else. Thank you, Madam Chairman.
I want to kind of follow up on the phone situation. So what about phones that are issued through or by the Tiger Athletic Foundation? Are those phones logged?
So the Tiger Athletic Foundation is a 501c3 that does the fundraising for athletics. So the phones are issued to department staff, and then TAF actually pays for them, but they're still athletic department property. We are issuing it to our employees. They're being logged. So that's a payment issue. It's not a.
So they are logged.
Yes, absolutely.
So we should be able to get those phone records.
Yep.
Okay. All right, great. Thank you. Senator Jackson.
I'm sorry, I had to leave. Mr. DeQueer, Attorney DeQueer, I know you're good. Have you found that yet? Because I know how you are. I went to school with your brother. You guys are well versed in the law.
Yeah, the notice provision in Les Miles.
Please give him the microphone, please. Yeah, thank you.
The notice provision in Les Miles' contract simply says it requires notice from the university. In checking with my office back on campus, they have advised me that that notice is considered a function of the athletic director and the president.
No, I understand about that notice. I'm talking about the 1.5 million.
Yeah, so the board approves the payment of the contract amount. The board would not have to approve the payment of the buyout provision because the buyout provision is part of the contract when the board approves.
So $1.5 million can go out of the university's budget to pay someone that's leaving without board approval.
The board approved the buyout schedule is part of the contract approval process. So
I understand you
Yes,
You approved that. But when we were ready to pay this out,
yes.
it didn't have to go before the board again.
No, not a second time.
Wow.
There's a schedule. If
No, I get
he-
the schedule, but this is the thing. They may be fired for cause, right? So what I'm saying is that you can be fired for cause,
Yes.
or you can be fired with no cause. So the board never hears how the determination was made to classify this termination for cause or no cause, which means we pay out $1.5 million. And I'm stumbling because I'm sitting here trying to just grasp my hand. I can't do it. Head. That's what I'm saying. I'm done. $1.5 million, right? And seriously, so I want to know if that's going to change. I really want to know, because if we're saying someone is leaving our university without cause and we owe them millions of dollars, I not only think the board should approve the amount we're paying them, even if it's in a contract. I think the board needs to research that person's employment file before we and really research the determination and how that process was made. Taylor Porter, for example, just said this, Davis, and this is serious. Taylor Porter has a report. Did Taylor Porter take any part in the review of his contract when he was terminated?
I don't know about 2016.
Okay. Who was the, I know you're the executive counsel now.
General counsel, yes.
General counsel. Who was the general counsel then?
2016, it would have been Mr. Tom Skinner.
Okay, in 28, and you said he left in 2018?
No, it was I started February of 2020. I think he departed in maybe December of 2019.
But I mean, when did we pay Les Miles? See, I'm stuck on this $1.5 million. I'm stuck on paying somebody. I'm just going to tell you, I keep saying Les Miles. When did he leave with our money after harassing our girls? I want to make that real clear. When did Les Miles leave with our money while harassing our girls and not being able to be in the room, and we said he didn't have cause? When did that happen?
I know that he left in September of 16, but the payout was when? November 15th of 2018. Was that when it was actually paid out? It was agreed to on November the 15th to pay out the 1.5 million. When it was actually paid out, I don't actually
When was the
have that
decision made to pay it
information.
out?
2018.
Yeah. So in 2018, who was the general counsel?
It would have been Tom Skinner.
And he no longer works for us. He no longer works anywhere in the state of Louisiana for the state of Louisiana, right?
Right.
So he's no longer available for committee. So the athletic department records. Let's talk about that.
And just to put it in context, the termination in 2017 in his contract, the buyout was actually $12.9 million.
Help me understand.
But they negotiated.
Okay, hold on.
But they negotiated it down for prospective employment. So that's why you're talking about the 1.5 you hear reported.
Okay, so we spent 1.5 million.
I need to, and I'd have to confirm that number.
Because if
I
we
don't know
spent
it.
12.9 million, we can shut the committee down. I'm about to call the district attorney because y'all have robbed the state, like for real. And y'all laughing, but I'm serious. Now let me say this: if we spend 12.9 million, shut it down, get the district attorney, attorney general, and inspector general over at LSU. And I mean it, because we have schools who come in here asking for $5 million. We have Southern University who comes in asking for $5 million, $1 million for. We got what, ULL, and Hammond, my beloved ULM, Grambling State University with buildings with ruins in them. You can drive through some of these campuses around the state, and they can't even get a good. Grambling just received about a year or two ago a good athletic workout facility. We're still building Grambling University State Library. It's about to get real personal to me. We still have kids staying in dorms with leaky roofs. So I know you have to get the information. I'm not fussing at you. You weren't there. Thank God you're there now. That's what happens. You know, are you a Southern grad? I don't want to give you a compliment if you graduated from LSU. Just checking. But I know your brother graduated from Southern University Law Center. And we're
We
proud
will
of
get
it.
the information.
Okay, solely I get it, because let me tell you, and this is where I get very serious. As I look at the ruin of buildings and facilities around this state, and it's going to be personal for HBCUs who are still waiting on their fair share of dollars. I don't care who raised it and what happened. For us to pay money to someone who sexually harassed our students without this board having the information they needed to make a valid decision, and it was not you as general counsel, but it was somebody who we paid good money to. It was somebody, you know, it's almost like the state is being raped over and over and over again financially with cover-ups. Oh yeah, who paid that out? And I know I need to get out the mic because I'm not emotionally ready for all this. This is
The state? Was it the state? Yeah.
yeah. Who paid it out?
It would have been TAF, Tiger Athletic Foundation.
Oh, Tiger
Or athletics.
Foundation. Okay.
Yeah. So we just use the Tiger Athletic Foundation to have a good time, pay out folks that we shouldn't be paid. No, I'm serious. Go ahead. Go to somebody else because my comments are going to not be senatorial in a minute. As I look at the public defender's office who's begging for money because they're defending 300 and 400 people a month, one attorney. I mean, I can just, let's just talk about what's happening when we have yellow shirts every year here for parents for children with disabilities asking for just $2 and $3 more million for waiver programs so their children can stay at home and not facilities. I'm on drama because this, you know, I was good until I hit this. And we talking about $12.9 million buyouts for someone who harassed our girls. And I'm sitting here with a board member who's trying to be diligent that didn't even have the information when the buyout was effectuated. So this is what I'm going to ask for because I know at some point my senatorial hat's going to go off and I'm going to go mom, aunt. And I'm not, you know, because, you know, I'm a mom, aunt, right? Yeah. And I'm going to take the place of who I think these girls needed when they entrusted LSU to be their protectors, when their parents paid tuition to this great institution, when these board members were blindly led to pay someone that much money. So I'm going to request the records because although we can't touch the Tiger Athletic Foundation and their money, that may not be subject to public records. The decisions made by that athletic department during that time are subject to public records. And I want them. I want to know who was involved, who made the decision to say no cause of action, who made the decision to ask the Tiger Athletic Foundation. Because people say, oh, no, it's not the state money, it's free. We got boys playing on that field every day. We got boys playing on the basketball court. We got girls with hopes of going to gymnastics and, you know, in Olympics. Every cent raised in that athletic foundation is based on the performance of kids we should protect. So I don't care if people consider it private money. It's on the back of kids we didn't protect. And when you take those children's backs and raise money, and you don't spend it on them or their programs, you give it to a coach and not you. So hear what I'm saying. This is not directed to those at this table who didn't know, but you give it to a coach that repeatedly harassed young girls. It's not private money. It may be private legally, but the Tiger Athletics Foundation would not exist but for those athletes and those students. If you didn't have a football team, a gymnastic team, a basketball team, a baseball team, or whatever else, there will be no need. And all of that is our children. All of that. And I know I went off kilter, but somebody needs to say this. We can talk all the way we want about private money, but that private money is raised off of the performance of our children, and it should be used to enhance their programs. And at no time should someone who harassed these girls, killed their dreams, made them feel lower than low because a university didn't protect them, get that money to leave. They should have been escorted out of the door in handcuffs and made to face their day in court for what they did. But at no time should money raised on these children's back been paid to him. And I know you didn't know. And you're a mother, so you understand what I'm saying.
I do.
And when that hit the paper, I can only imagine how young ladies that had been harassed by Les Miles felt. I can only imagine that we paid him to leave after he harassed our students. And that's not on you. But I want to know who it was on, Attorney DeQueer. And I want to know who made the decision, where the documents, where the meetings. If it was the president at the time, I'm sure they have to leave their documents. And if we just don't have a paper trail, we're going to have to admit it. But these are private funds raised off the backs of our children that should go back to our children. And Tiger Foundation is set up to make sure these programs not only excel, but make national headlines, right? And giving that money away to someone whose employment file really showed the truth of who they were. We failed. We just didn't fail the girls that were harassed. We failed everyone at the university. We failed every student and every parent that trusts their money to us. We failed every citizen of Louisiana because their tax dollars go to LSU. We failed every university that has dilapidated buildings and subpar programs because we can't send money. Because at that same time, and I'm going to end with this, Mrs. Chairman, because I'm serious, like this is unreal. At that same time that was happening, we were cutting higher education by 60%. We were cutting and raising students' tuition, and these schools and these universities were here with autonomy bills to raise fees and tuition on the backs of our parents and students while we paid someone to harass our girls. That, to me, is disingenuous not only to the board who had to sit through it and didn't know it, but to the legislators who thought they were doing the right thing and making sure that the students had what they needed. So we made students pay. Because what we cut, they paid. When Louisiana was in a deficit, they paid. While he got rich off of us. And it's not just him, but it's him with a 12-point-some million buyout that was negotiated down to whatever it was, and I think it was a tiered approach, so we don't know now. I want his employment file. I want every name of everyone that was in the room to make the decision to terminate him without cause. I want everything surrounding how we got to the point of paying him, and I know the board didn't do it. But I know if you would have known when you sat there for the 4 or 5 weeks or 6 weeks, I know you would have said, hold up, we're not paying this. And that would have been a governing decision had you all been given the information you needed. I want everything. Because I'm tired of playing games. And then I want to know if there's any employee left who made that decision. Anywhere in the state of Louisiana, regardless of what campus they're at. If they made the decision, if it's an attorney that's employed by the state, if anybody gave advice to pay him on his way out the door, I want to know. Because either they didn't know, but someone covered this up. And it's just time to know who covered it up. And there's other incidents, but on this one, it's time to know.
Thank you, Senator Jackson. Well said. I'm going to kind of switch gears just a little bit and talk to you, Mr. Sanders. I've been trying to find where I read this. We've read so much in the last couple of days, but tell me your role. Tell me what your position is and what's your role.
Yeah, I serve as the Director of Student Advocacy and Accountability. Our department addresses behavioral misconduct, academic misconduct, student organization misconduct. We also address student grievances. We house those within our office to meet with students and address grievances. We also assist students in crisis, distress, or concern, respond to student deaths when we have those unfortunately on our campus, and also assist transfer students as far as transfer student programs.
So when a student comes, or if you hear of an issue, what do you do? If there's an issue, if they're not in compliance or something along that line, what is your role and what do you do?
So usually I'll receive the reports regarding the misconduct, unless it's Title IX. Those get routed directly to our Title IX coordinator. I'll review it to see if it's information that supports possibly a charge under our Code of Student Conduct. Code of Student Conduct is something that is the guiding document we follow in our process. If I think there could be a possible violation of the code, I will then issue charges and assign it to one of our hearing officers to charge the student, move forward in our process, and ultimately issue an outcome for the student.
So in one of the reports I read, it seemed like a student had concerns. Her rights had been violated according to Title IX. And when she reported it, instead of it being addressed with Title IX, she seemed to be disciplined for it. And that's where your name actually came up, but I'm trying to find that right quick.
Are you speaking to a candle violation? Is that the situation you're speaking to?
Yes.
Looking to Winston just to make sure I don't want to violate any federal laws with FERPA and the educational records. I can speak to that process. I don't know that I can speak to the details of that case because, again, don't want to violate any student privacy laws without a full release from all students involved in potential cases. But for us, I don't address issues within residential life. Residential life does routine health and safety inspections every semester to make sure students don't have items in their rooms that could provide a danger if they were to catch on fire or burn out the building, perhaps harm or injure someone. They give an announcement to those students in advance that they are doing a health and safety inspection. Once they go through the rooms, if they find any items, they will remove those items from the room, and then they will send the student a letter telling them that they have a warning from their office and that they have removed the item, a candle or whatever it may be, and that's outlined in the letter from residential life. That quote in that article is mischaracterized. There's actually a error in the report from Hush Blackwell. They asked me a question about a case. I gave a response. When I gave that response, they connected to a totally separate case that I was not talking about, that I had no involvement in, no connection with. Someone as a director of my position would not be hearing candle violations on a university campus. Again, that happens locally and within residential life for our process. That's where that information came from.
So, okay, so because I'm having such a hard time trying to find this, but I know that I read it. But in 2018, there was another situation where there was individuals who had a situation with the rape situation, and when they shared it with you, it's stated that you didn't take any action.
I have no knowledge of any case like that. If they were found responsible for misconduct in Title IX, I would have issued an outcome to that student as per our process.
Okay. 2 other female students said Sanders failed to contact witnesses in their case against a fraternity member they reported for sexual assault in 2019.
Do you know which page number that is? Which them was?
Actually, I'm reading it from article.
Okay.
But I can't find it in the report.
That's okay. Well, can you repeat the question? I'm sorry that you said the.
I just scrolled away from it.
It was basically that I didn't contact other people that the person said I should have contacted, correct?
Yeah, 2 other females students said Sanders failed to contact witnesses in their case against a fraternity member they reported for sexual assault in 2019.
Can I speak to specifics on that? So in our process, Title IX does an investigation. They meet with folks and develop a report. If they find that student responsible, they send that report to me as the Director of Student Advocacy Accountability. My role is then to issue the outcome to the student. So as part of that process, I will review the report, They've determined what violations occurred in Title IX. I'm also looking to see if there's any possible Code of Student Conduct violations as well, because we want to address all those things with the student if there are. Once I determine those things, I send a charge letter to that student. They have notification and due process in our process.
What does due process look like?
Due process, that is a federal, actually, mandate for us.
So what happened in the due process? So what is y'all due process? What happens when they receive the letter?
So the letter is to invite them to, they list out the possible charges under the code that they may have violated, and then they come in to meet with me to review those. I'm not rehashing the case with them because I already have a summary basically from the investigator about the process and about what they discovered from the investigation. I asked them, is there any additional information you'd like to share with me that you didn't share with the investigator? Sometimes, and actually oftentimes, the charged student will share additional information. Perhaps they forgot to tell the investigator something, they've thought about it since then. They're providing other information, for me to consider when issuing the outcome. Then obviously I review the process with them. We also make sure that they are also connected to resources and services as well as our complainants in a process. And then I then also meet with the complainants as well. So if there's I'll meet with multiple complainants, and also ask if they need any additional support or services. We're not rehashing everything, so we don't re-traumatize someone. We are trauma-informed investigators and want to make sure that we uphold those pieces. But there could be additional questions from the report I may have questions about because I didn't write the report. That's not my language in the report. I don't want to make sure that it's accurate so I can give the most fair and equitable outcome possible when reviewing that information. And make sure they understand their rights in the process as a complainant as well. In Title IX, both parties have equal rights in the process. So if one party has a right to an appeal, so does the other party as well. We want to make sure that is communicated to them and they understand those things. Some students will say, well, did you talk to those other folks may have information? If it's information relevant to the case and or relevant to assessing credibility, I will follow up on those things regarding specific situations with students.
It appeared, I couldn't find my article, but also, and just as I recall from some of the young women who came in the last committee hearing, that it seemed like when they made a report, it seemed like there was some type of retribution to them, that something they would have some kind of fine or something they weren't in compliance with, or something would come up after it appeared that way, and you were responsible for those disciplinary actions.
I think that's speaking to the candle violation situation.
That was one.
Again, those are things are occurring that are not under my control. I think that they are routine functions within the university. I think timing-wise was unfortunate. It happened around a time that we were also meeting with that student, perhaps for another situation. And
Representative Edmondson, I'm going to bring you on in a few minutes. I'm going to bring you on. Let me finish answering and bring you on, because I think you need to state that it wasn't just a candle. But go ahead and finish. Will you finish?
I was, thank you.
Okay. Representative Edmondson.
Thank you, Madam Chair. There was another incident, and I'm not looking at the report either, but there was one incident with a candle involved, and then there was another incident that one of the young ladies was reporting to us. It had to do with wine in the room. Yes. Are you familiar with that?
I am familiar with that situation. I will tell you that again, that was a residential life process and procedure. The student was solved perhaps with alcohol. They reported to their folks. They went through their process with that student. Again, that wasn't something that came to my level. That's not something I would normally address from a student advocacy and accountability perspective. Again, those are routine functions that our residential life friends hear for those respective cases.
So this may not be the correct wording, but in other words, at your level is higher than incidences like that would be handled by, what was the group you said?
Residential life. So that's the
right.
folks who are living on campus. They're handling those things through the code and the Living on Campus handbook. I think that some of the issues with that information in the Hush Blackwell report, no one from residential life was interviewed part of that process. They didn't get to share their process with them. They didn't get to be asked questions about those processes. They automatically assumed that was me, and that was in that report, and that is a mischaracterization of our process.
Okay, can I ask you a question about your process? And this may just be me, but I'm just putting myself in a place where a young lady maybe have been violated. This process that you're talking about seems very laborious to me. like a lot of stages. Is that a federal? Has that been laid out federally? That's the way you have to handle situations?
Federally, it just changed. It just changed August 14th, 2020.
Okay.
We have a new process that now let's
Is it
basically
going to be less laborious than the one that y'all been going through?
correct. It's laborious. I don't know. It depends on who you ask. There's different perspectives in that.
Well, yeah, I'm just saying how I feel about it. I understand.
Not as many
just tell
steps.
me what it's going to be.
Not as many steps, but the new process does allow attorneys to directly question complainants and victims. So in our process, we don't allow that. Attorneys can serve as an advisors and be present with the student for support. They can't speak on behalf of students. In the new process, per the federal Title IX regulations, it now allows attorneys to fully participate in our process. Some would say that that could be problematic because if I don't have access to an attorney, but the other party does, they're at an advantage, right? So there's some disparity issues, some equity issues, and those kinds of things. It is less steps, though, than what our previous process was, is it's basically an investigation by Title IX, and then a hearing occurs. In our current process, that hearing is actually an administrative law judge actually presides over it.
Right.
And then we have two other folks that are part of that hearing that also are part of that decision-making process.
So the new process goes into effect. It's already gone into effect?
That's
and that
correct.
is as per federal policy, federal law?
Yes, that was Betsy DeVos and her, working on for 2 years and then implementing there at the end of spring.
So have y'all had any of those yet?
We've had 2 so far, finished the process.
Okay. And how do you think they lined up as opposed to what you used to do?
I think this is new for everyone across the country. I was in lots of webinars this summer, and so was our Title IX folks, and I'm sure General Counsel, just figuring out navigating these waters to see how this is going to work. I think we've learned some lessons along the way. I can't speak on behalf of Title IX because it's really a Title IX process, not our process. But I think as a university, I would say I think we were trying to make improvements and steps along the way to improve that process moving forward.
Okay. Because it just seemed like from really the other hearing, and it's the first time we talked to you, Mr. Sanders, but it just seemed like it was just so many steps, and it just maybe the alleged victim would just give up because it was just like just too much to deal with.
We explained in the last hearing, effective August 14th, 2020. The Title IX process changed, and it has fewer steps. The part that we're still evaluating is the new regulations require in-person cross-examination of a complainant, of a victim. And that left a lot of schools unnerved because a lot of people who are victims of sexual assault don't want to have to face. But the new federal regulations require a hearing that's like a mini trial. We use an administrative law judge, and if a student brings an attorney, we now have to let that attorney participate. And if that attorney wants to cross-examine the person making the allegations, that person now has a right by federal law. So it's fewer steps, but what Jonathan's referring to is we're still uncertain if it's going to be better, because it provides a different type of procedure that we think may not be as well received.
And if that doesn't work for you, is anybody up to letting the feds know that that's not a good process for
There were, this summer, in the middle of COVID, there were probably 24 schools that filed an injunction to stop
So
the
if that's what we need to do, that's what we should do.
They did, but they lost, and the regs were implemented in August. No, lots of schools got together and tried to stop the implementation of the new regulations, and it failed.
But now that it's implemented and you have testimony or you have a basis for it not working, I'm just saying don't give up on doing that if that's what needs to be done.
We're not, but the prior regs, the prior inclusion of sexual harassment into Title IX in the very first Dear Colleague letter in 2018 was announced by then Vice President Joe Biden. So we know changing the regs back to what they were is very high on his priority list. So we think that's going to happen quickly.
Okay. Thank you.
Thank you, Representative Edmiston. Let me ask this question before I go to Pro Tem. Where is Mr. Sanders in this organizational chart? I don't see his name listed anywhere. If someone can tell me where he is, because if someone has an issue or a concern, because it just seems so ironic that every time or when sometimes when there was a foul case or situation with Title IX, that seemingly there was some disciplinary action taken. So it seems somewhat to me kind of retaliatory. Who would they report to? I mean, that's what I was asking about the due process. If they have an issue, who do they go to?
If you look on page 19, where you see in the middle underneath the Provost, Academic Affairs, Student Affairs, Vice President Jeremiah Shin.
Yes, I see his name.
Underneath Student Affairs, Jonathan can tell you, are the various components of student life.
Yeah, and I report to the Dean of Students, who reports to Dr. Shin.
So you are not on the chart. And who else is supposed to be there?
Well, there's a lot of, there's a lot of people.
We have Residential Life, Career Center.
So if a person had an issue, how do they go to the next person up? Is it Jeremiah Shin?
The appeal. If somebody's unsatisfied with you, where would their appeal go?
So my boss would be the Dean of Students, and also they also serve as a Deputy Title IX Coordinator for students.
Who's the Dean of Students?
Currently it's Dr. Brandon Common. He just started in December.
Is he on here?
I don't think he's on. I don't know.
He would report to the box that says Jeremiah Shin.
So everybody, so if someone had an issue, if they had an appeal and they wasn't satisfied with the outcome, or they felt that they were wrongly accused, they go to who if they are not satisfied with the rendering from, or if they want to argue your citation?
Okay, so I think you're talking about the Code of Student Conduct process. Let me talk through that real quick. So in the code process, the student would meet with a hearing officer. They're making a decision about the case. If the student does not agree with the outcome of the hearing, they can have the case reheard by a university hearing panel. That university hearing panel is a faculty member to make quorum with a faculty member and a student, and the third person can be a faculty, student, or staff. In Title IX cases, both the complainant and the respondent both have equal rights in the process. Again, this is prior to August 14, 2020, to also elect to go to that hearing panel if they didn't agree with the outcome from, again, my decision. That panel would rehear the case, and then they would issue an outcome for the student. That outcome could be less punitive than the outcome I gave. It could be the same outcome that I would give or the hearing officer would give, or it could be more punitive. It just really is what those three people think after reviewing the information and hearing from the folks a part of the case. If someone believes that they have, there's been bias in the process for the university hearing panel, if they believe that there's new information available that was not available prior to the hearing or during the hearing, let's say a video surfaces 2 days later after the hearing, they think it would have impacted the outcome. That's also an appealable offense in our process. And third, if we didn't follow our process, they can appeal for one of those three reasons to our Dean of Students, who is currently Dr. Common. And again, one of those three criteria is the reasons they can appeal that outcome to the Dean of Students. And then they would render a decision based on the appeal.
Is this somewhere in writing?
Yes.
It is.
In terms of the entire process?
Yes.
So even young people can know where to go if they feel like they have been wrongly accused, or if they want to appeal or whatever.
And Senator, I want you to understand, this is the student conduct process for everything except for Title IX violations.
Mm-hmm.
Title IX violations go through the Title IX process, and everything else from noise ordinances to drug use to whatever goes through him.
Do you know why the other individuals are not listed on the organizational chart?
Because building out what's underneath Dr. Jeremiah Shin would be like a whole nother page. We can get you that page pretty easily.
Okay.
In fact, I think it may be on the website. I think that organizational chart is on the Student Affairs website, but we'll get it for you.
Okay.
It's built out.
Okay. Senator Mizell?
Yeah. Thank you. Sorry. Thank you, Madam Chair. God bless you. Thank you. A few things, but I'm gonna just jump right in. I can't tell you how we appreciate it because there's so many moving parts to this, and your name kept coming up.
Yes.
In a very disturbing way.
Yes.
And so we're really glad that you took the initiative and showed up today. But I'm just gonna jump right in. I've got questions about the process and about the numbers of students expelled and what have you. But this is the crux of it. I have a colleague who's a rep, and her question is bluntly, did you ask the girl that had called about a sexual assault what she was wearing?
Can I answer that? Her? Okay. I did not.
You did not. So how did that get into Hush Blackwell?
I'm assuming that was something that someone shared with them, but I was not asked specifically about that by Hush Blackwell that I recall.
So you're not parsing words on me, are you?
No.
Okay. Just want to make sure.
I'm not saying that didn't happen to them in somewhere in the process, but I did not do that. And I also, there's another professional staff member part of that meeting. Mm-hmm. I contacted them when I heard that in the media just to have a recap of make sure that something occurred there that I wasn't aware of. And they also confirmed that as well. They don't recall me asking that question.
Okay. Well, that rep couldn't be here today, and that was a great concern to a lot of us. Another concern, and I want to get into as Mr. DeCoeur said that you're not Title IX. We got it. Yet you are brought in on Title IX, and you assess code violations. And those, give me an example of a code violation.
Marijuana.
Okay. So you're looking at ancillary bad behaviors that would have been part of the Title IX situation. Is that what that is?
So prior to August 14, 2020, again, the process changed. When I answer the question, I think probably where the concerns come from, I think it's probably up before August 14, 2020. Again, the Title IX is investigating the case. They are coming to a decision. So if they find the student responsible, then they forward that case to Student Advocacy and Accountability, either myself or another staff member. I'm not the only person who hears Title IX cases. I probably hear the majority of them, but I'm not the only person on our team that does that. Again, I'm looking at that report. Is there other things in there we need to address from the Code of Student Conduct? I'll add those charges to the case, and then I send a charge letter to the student. And that student is then notified about a meeting with me, and then we review all that information and basically give them due process. I also then try to meet with the complainant as well. Again, not to have them retell their story. That's not the goal of the meeting. I let them know I've already read the report. I already know the information here. Is there anything else additional you need to share with me that I need to know before I issue this outcome? Or things you'd like me to consider? What are you looking for from this process? Those are the types of questions I would ask them to have a better understanding that, to make sure that, again, I'm making the best decision possible based on the information I have to address that issue fairly.
But you are the person that would decide whether someone was going to be expelled for those code violations.
Correct.
And my understanding is of the 46 students that were found to be responsible, only one was expelled. So can you explain that to me?
Yeah, so I started my role in the fall of 2016. So I started mid-September of 2016. We have what's called an outcomes guide that we use for our department.
I don't assume we know what that
Okay,
means.
I'm going to tell you.
Okay.
So it's a guide. So it's someone asked me, where did it originate? I don't know the answer to that question. I know that the oldest document I can find on our shared drive is back to 2011, is the first one I can find as far as like a revision of it. In our outcomes guide, it lists when we issue outcomes for hearing officers, we want to make sure that we're being consistent, right? So we want to make sure that just because someone gets a hearing with someone else in our office versus me, that we're being consistent in those outcomes. Mm-hmm. We do know that we do have to look at mitigating and aggravating factors of cases because that could then obviously impact that outcome as well. That outcomes guide was in place prior to my arrival in that role, and we have continued using that outcomes guide. As part of the recommendations from as a result of this process is that we're going to revisit that outcomes guide to make sure we are holding people accountable to the standards LSU determines is the standards at LSU, and we will make sure that we support those things. these outcomes I take very seriously. These are not my outcomes per se. These are on behalf of LSU. And if we believe in a community they are not punitive enough or not harsh enough, we will change that. And again, that's not my decision alone. That happens with a group of people, and probably faculty, staff, and students would be involved in those decisions. But again, that's something we're going to do and committed to do moving forward.
But you didn't answer my question, because what I really want to know is, how do you arrive? Is there some magic scorecard? Okay, you did this and this, that's 3 points. This is how I'm adding up your behaviors to get to the point of an expulsion as compared to a suspension. Because otherwise, if it's your judgment compared to my judgment or the chairman's judgment, that's not fair to LSU or the student, the complainant, anybody. So how do you arrive at these guys are going to be expelled, this one's going to be suspended, or this one's going back to class tomorrow like nothing happened?
Yeah.
Oh. No, so explain that to me.
Yeah, so we were looking at, anytime we find a student responsible, we're looking to see, is this a pattern of behavior? Has there been prior incidents the student's been found responsible for? If so, that factors into our decision, especially the behavior is similar to the behavior in question that we're meeting with that student about.
Right.
If they had an academic misconduct case and now we're talking about Title IX, I don't know that necessarily would impact that particular case. It could, if it was poor decision making or whatever it may be. But also just looking at the most appropriate outcome based, again, the outcomes guide, and determining, again, about mitigating and aggravating factors. If there's aggravating factors to consider in a case, that may bump something up to expulsion versus being a suspension for a case that may on the surface look the same, but actually when you dig in, there's aggravating factors that, again, we have to consider that would bump that outcome up to a step up from whatever we were looking at.
But that's in your judgment.
You're
deciding how it's bumped up.
Correct.
So this outcomes guide sounds like it's just something to take the blame, because if the system has not put somebody's record in, then you're not seeing their former pattern of behavior. So it's not worth anything. I mean, it's just not worth anything. I mean, this is why we're here today, and that's. I thought you were gonna make me feel better, and you've made me feel worse. So, but it's not about how I feel. It's just if I'm here much longer, it's going to become about how I feel. But it's one of those things where this should be the most trustworthy process ever. That this is how we're constantly certain that this outcomes guide has this magical ability to treat everybody fairly, and it doesn't sound like that. I mean, and how we could have 46 students that were found responsible for Title IX misbehaviors, for lack of a better word, and one expelled. That one guy, or whoever, woman, man, whatever, must have been some really bad son of a gun, because he was the only one expelled of the whole thing. So anyway, I'm finished, Madam Chairman.
Thank you, Madam Pro Tem. Senator Jackson.
I know y'all sick of me. I know. I missed the last meeting, Mr. Sanders. So I know Senator Mazzell visited this, but I want to make sure, who reviews the decisions you make?
It's talking about in the process, or
Yes,
just in
the process.
general? In the process, if someone does not agree with the outcome that I issue, they can request a
No, I didn't ask that.
Okay.
Who reviews your decisions before they're handed down?
I report to the Dean of Students. I mean, that's...
Does he or she review every decision you make before you? Okay, so you're judge and jury?
I issue outcomes for cases.
All right, so that's what I'm saying. There's no one else in the room. It solely comes to you?
Wow.
In difficult, challenging cases, I always consult our Dean of Students, perhaps General Counsel's office, other parties. Again, if there's other things to consider, I don't operate in a silo by any means.
How long have you been there?
At LSU? Since started in 2006.
How long have you had this position where you review these cases?
Fall of 2016, mid-September.
Did you ever review any Les Miles cases?
I don't have any purview over faculty or
Okay,
staff.
so your only purview is students?
Correct.
Okay, So you make a decision, the student doesn't appeal it, it's final.
They have 3 days to.
I say if they don't appeal, it's final.
Yes.
Okay. So when you make that decision, let's say student comes in and complains about sexual harassment. And what's your official title?
Associate Dean and Director of Student Advocacy and Accountability.
So are you obligated when there's a sexual harassment complaint to send it to Title IX?
Yes, we're mandatory reporters.
Okay. So have you mandatorily reported every complaint you've received?
Yes.
Okay. And then so Title IX doesn't do their own independent investigation outside of yours?
Yes, they do.
Okay. So have you ever had a time where Title IX didn't agree with your outcome?
I'm sorry, I didn't.
You make decisions. I think, yeah. Has there ever been a time that you made a decision on a case and Title IX didn't agree?
I've never received any feedback from Title IX about any of the outcomes I've given.
So is Title IX investigating while you're investigating?
In our prior process, Title IX investigated and came to a decision about responsibility.
Okay, I'm saying you've been there since 2016. A complaint comes in and you send it to Title IX. Do you wait on their decision?
Yes.
So you don't really make the decision.
Whether someone's responsible or not, that is Title IX's decision in the old process. New process, it goes to a hearing, a live hearing.
No, I'm saying in the old process. You issue the punishment that Title IX tells you to issue.
That's incorrect. Title IX is finding the student responsible. I'm issuing the outcome to the student, the penalty per se to the student.
Okay, that's what I'm asking. Title IX says that the student did do this.
Right.
And when the Title IX says the student did do this, you determine the punishment.
Correct.
Okay, is that for athletes as well?
Yes.
Is it reported to their coaches?
All outcomes for us for student athletes, so whether it be academic misconduct, Title IX, any violation, we copy athletics on those, charge letters, and the outcomes.
Okay, so you've been there for since 2016. Have you ever issued a ruling that says that a high-profile athlete should be disqualified from a game?
That would not be my purview in student advocacy accountability. I don't have any rights to prevent student athletes from playing in games.
But I thought that you issued the punishment, and so if you determined, well, let's say it was a student athlete, and that student athlete was found to be responsible, then couldn't you say they couldn't participate in sports on campus because of what they did?
I have suspended student athletes who then, as a result, are no longer students and could not participate in their sports.
Okay, so you have to suspend the student.
Per our Code of Student Conduct, that's the...
Right, what other punishments are you allowed to give to students?
In our code process,
yes.
It ranges from warning to expulsion. Mm-hmm. Warning would be the most limited outcome we could receive. We actually don't even use warning that often in our process. That's mostly residential life who uses warnings in their process. The entry level would be disciplinary probation without restrictions. So again, disciplinary probation just means if there's any other violation occurs while in probation, their outcome would obviously increase based on that because there's a pattern of behavior. Step up from that would be disciplinary probation with restrictions. With restrictions does prevent students from doing study abroad, holding leadership positions in student organizations, those kinds of things. Anything that says that you have to be in good standing with LSU, those students wouldn't be able to do. Step up from that would be deferred suspension. It means if the student is not suspended, but if they have any other violation of the code while in deferred suspension status, they would be suspended. Suspension would be separation from the university for a period of time, and then the most punitive outcome would be expulsion.
Okay, so did you ever receive any of the GEIS complaints?
So when Ms. Scott spoke this morning, she said she contacted the judicial office. Mm-hmm. She contacted our office, I believe. She contacted Student Advocacy Accountability. I did not speak to Ms. Scott. I did not staff member who spoke to her. But after that meeting or that conversation occurred, our staff member sent a report to Title IX.
And so did Title IX send something back to you?
No.
So what happens when you send a report on a student to Title IX and you don't receive their conclusion? You just let it go?
No, the conclusion was from general counsel and from Title IX that we didn't have jurisdiction on the complaint. So it was never kicked back to me to address from a Code of Student Conduct perspective or a Title IX perspective.
So you sent it and you didn't have jurisdiction because he was no longer a student?
Correct. I believe it's no longer a student, and also the Title IX piece that Winston talked about earlier.
Right, right. And so in USA Today, and I hate to bring this up, but you know, we're here to get the facts. There's a student, female student, who says that when she came in, you questioned her about what clothes she wore the night a male student raped her while she was unconscious. That wasn't Geis. Who was that? Who?
I can't disclose that.
Okay, so you can't disclose who it was, but you remember it because you at least not can disclose the name. Let's talk about that incident. Is she lying? Did you question her about what clothes she had on?
I do not recall asking a student what clothes she wore that evening for any of that case. If I was to ask that question, I'll give you an example. If incapacitation is something we're reviewing and looking at, both students perhaps were under the influence, either alcohol or drugs. There's one student believes that consent occurred. The other student says, I don't recall having sex or giving consent.
Right.
Then I may have to look at incapacitation in that piece. I may ask a student, what's the last thing you recall? Were your clothes still on when your recollection of that? Mm-hmm. I may ask them how much clothing they were wearing. So if someone did non-consensual penetration, that they would have to remove that clothing. That would be important for me to know, perhaps.
Okay, so you might have asked her, and I want to be very fair. You may have asked her what clothes she was wearing because you needed the clothes for further investigation.
No, that's not. What I'm saying.
Because usually when they do a rape kit, they'll say, see, that's where I'm getting to. Usually, when someone reports a rape, you're asked to bring your clothes in. So that you can see if any, just in case the investigation goes further, right? And if the investigation goes further, there may be semen, there may be hair, there may be DNA or anything. So that's what I'm saying. Maybe, did you ask her for that reason, what clothes she had on?
No, I do not think I asked her for those reasons.
Okay. So protocol when someone reports a rape, what's your protocol?
We would report it to Title IX. And also, we also notify Lighthouse too, so that they can reach out, provide services as well, because they are the confidential.
What service?
They reach out to the student, provide resources.
Okay, if someone reports a rape, your procedure is not to call the police because that's the proper agency to investigate that rape. Because rape is time sensitive. Evidence of a rape is time sensitive. You don't want the victim to take a bath. You don't want the victim to wash or discard their clothes. I'm asking, if a student comes into you and reports a rape, what's the first procedure you follow to protect that evidence?
Senator, I think the confusion has to do with when rapes come to Mr. Sanders' office, it's the result of a Title IX complaint. If you're asking him, what does he do if he's the first person
right, that's
to
what,
receive?
see, this is what I'm confused about.
He's not a first, he's not an office where his office isn't an office if you're the victim of sexual misconduct. You don't call his office. That's not what his office does. His office is on the judicial end of the student conduct.
So you get it after the investigation has occurred?
For Title IX, yes.
Okay.
We would refer the student to Lighthouse. We would provide resources, support.
And see, let me tell you what my confusion is at, gentlemen. In one instance, you're saying he gets it from Title IX. In another instance, he said about 10 minutes ago, when he gets a complaint, he refers it to Title IX. And so that's my confusion. He's saying he refers to Title IX. You said he gets the complaint from Title IX.
If
that's what I don't understand.
Every employee on campus, if they get a complaint that includes sexual misconduct, has to refer it from Title IX. But between him starting in his job in August of 2020 the Title IX process was bifurcated. The finding of responsibility occurred in Title IX, and if you were responsible, it was sent to his office for determination of the penalty.
So this is maybe my question. You questioned this female. So do you conduct the investigations? See, I don't know if Title IX is conducting investigations or you're conducting investigations. And I'm not being rude. And I know this is not current. I know you fixed it, so I'm not there. I'm there for the justice now of the young ladies, okay? So Title IX came in before this complaint came in. I don't want the accuser's name. I don't even want to talk about the victim's name right now. Let's use this case. So when did you get her complaint?
I don't know that information off the top of my head. I don't know.
So you were not the first person she reported to.
I don't know. I'd have to go back and look and see who she reported to first. I don't know that information.
But yeah, so he's probably not. So I'm trying to figure out, does Title IX investigate? I thought you were only. So how are you questioning her?
I would only be questioning her again if there was information in the report that was not, that I think that might impact the outcome, or the information that perhaps that the respondent had provided that they did not provide to Title IX. That oftentimes happens in our process. They said, well, I didn't share X, Y, and Z also happened, that night, or they. But
do you send it back to Title IX? Because at that point, when that triggers and you're sitting there and you say, okay, you didn't report this to Title IX and Title IX has made a decision and they didn't have this information, do you send it back to Title IX and say, look, this is an incomplete investigation because a student just revealed to me A, B, C, D that occurred and you didn't have that information, so I'm sending this back to you to further investigate?
We have. Okay.
So with her, did you?
Again, I don't want to speak to specifics because I think we're getting into a territory that might be violating FERPA.
Okay. Because she's, and I'm not trying to, and I understand legally, but this is my confusion. If you don't investigate, how are we questioning?
Right. Again, I'm not here to re-traumatize someone. I know that. I know the information in the report. I'm only asking any questions I might need to ask to determine the appropriate outcome. Is there any aggravating factors I need to consider for that particular case?
So it's kind of like after trial. I get it now. It's kind of like after trial. It's like after trial, okay? And the judge is doing the sentencing part. I'm sorry, you know, an attorney. So I have to get this in my mind to understand how this procedure works. And you're testifying before you get punished, right? But usually you'll ask the victim, what's the aggravating circumstance? That's not in the report already?
Usually not, because they're not usually talking about outcomes in the report. They're talking about the actual investigation.
Okay. And then you'll ask the the accused, is there any mitigating circumstances? Because we do that in court, like before we sentence people. Hey, what's aggravating, what's the mitigating? I get it now. So you sit as the person who sentences the person.
Correct.
Okay. Now it makes a little bit more sense. So in your sentencing, how would what clothes she wore be significant?
Again, I think we're speaking to a specific case. I didn't ask that question. Someone may have answered that question in the process, but
it was not you. So if she says it's you, that's incorrect.
I do not recall asking her that question.
Okay. And those are my concerns, is that this is what I'm seeing. And I'm not an expert, but I do litigate. It seems that the process in place did not offer these young ladies a true balanced review, right? And I'm going to ask you this, and remember, you know, when you're here, you sign a card, you're under oath, right?
Yes, I'm going to say that.
You're under oath.
Yes.
And LSU, you know, whatever. So has a coach ever called you in your tenure and told you, we don't need this guy suspended, we need him to play in this game?
No.
So you've never had a coach to try to influence you?
No, I've only had 2 coaches participate in our process before. They served as an advisor to students, and that's the only time I've ever talked with coaches in our process. They didn't speak on behalf of the student, but they sat in with the student to be their advisor. It doesn't prevent them from doing that in our process. I did let athletics know that afterwards. They told the coaches, please don't do that anymore in the future. Let someone else from athletics go with that
so
student.
Basically, you when you found it to be a problem that coach was present, you let athletics know that probably wasn't appropriate?
it's not against our code. I mean, a student can bring whoever they want as their advisor.
Right.
But probably doesn't look good, right? That
Right,
the coach is
right.
in our process.
Right. You know,
And it wasn't a head coach. These were assistant coaches.
But you just aired out from, just aired in caution and said this not a violation, but it doesn't look appropriate. Okay.
Yes.
I get it. And my last question is this, and I'm sorry, ladies, it takes me a while to wrap my hand around stuff that's legally not sound when we're talking about someone's legal rights. Past that, and I don't want to ask you about anyone specific, when you make a decision, who is it reported to?
Reported to the complainant and the respondent in a Title IX case.
Who in the school is that final decision reported to?
If it's a suspension, other folks are copied on those suspension letters. So our Vice President of Student Affairs, our Dean of Students, Director of UREC, Residential Life,
If it's a non-suspension?
LSUPD. Non-suspension, typically not reporting anyone else. I do an annual report, though, every single year that shows our outcomes, starting in 2016, or I believe is the first one we did with that. That information has been shared with faculty, staff, students. We've used that information in presentations before.
Okay.
I've never had anyone tell me from above superiors that they had issues with any outcomes our department was issuing.
So basically, if we wanted to look at the outcomes of any of your decisions, not the specific outcomes, but your overall outcome, we have that? Do we have those?
I provided to USA Today. I mean, I broke down the Title IX stuff for them, the stats. They unfortunately didn't portray it the way that I think it should have been portrayed, but we did provide that information to them.
So you got 16, 17, 18, 19, 20, 21. Is it 21 now? I can't even remember.
Yeah, it's 21.
I've been in this room
So-
so long, I think it's eclipsed. Maybe 22.
Senator, if you look in section 6 of the book they gave
That you
today,
gave us today? Okay.
that's the annual student accountability report for 2019-2020.
Section 6.
Yeah, it's the last section in the book.
Okay. What page are you on, Mr.
I
Shapiro?
think it's 128.
Okay.
And if you flip to about the 10th page of that document, it's titled Data Dump. It lists the statistical analysis of the outcomes in the student affairs process.
Okay, I'm looking at data dump.
So that's what he publishes every year on all the cases they hear and the outcomes. And they share it with the campus.
So like if I'm looking at the purple line of that report,
Which,
this is academic misconduct, behavior misconduct. Where is the sexual harassment portion of that?
they'd be under behavioral misconduct. We didn't parse those out for that chart, but it would be considered behavioral misconduct in that process.
What would it look like if they had?
Yeah, what they're asking, what would it look like if for the year of 2016, what would have been the number of sexual misconduct, harassment, complaints, abuse, rapes? Would that be under sexual harassment? Is it separate?
We label things PM 73. That's our process for sexual misconduct. That's the actual policy name.
Right, PM 73.
I don't know that I have that information with me today, but certainly something we can provide to you all. I do have the number of expulsions and suspensions we issued the year before I took my role, and then the subsequent years after. I'm happy to share that information with you if that's helpful.
So basically, if I go to behavior misconduct, that's the yellow line. And I understand that ranges from everything. I do understand that that's everything. That would have been like 600 and some cases you took up that year under behavior misconduct.
Would have been around 400, I think. I think that.
Page 134 on this report. So there was some rumbling about you being in the report, and I'm just going to blankly ask you, what did the report find that you did wrong? Did the report find anything you did wrong?
For Hush Blackwell?
Yes.
I mean,
In their opinion, I know it's their opinion, you have to vend yourself. Did the report find anything Mr. Sanders didn't follow protocol on?
There were some criticisms. I don't know if it's didn't.
So
follow.
where are his criticisms?
Ooh,
you mentioned the candle violation. That was one. The wine
Hold
piece.
on, counter violation. What's the counter violation?
We spoke about that earlier. It was the situation.
I was out trying to
I'm
congratulate
sorry.
my best friend who's getting married today, who I couldn't be there because I'm here.
It was criticism that I held a student accountable for a candle violation while they were going through the Title IX process. I explained to this group earlier that I don't hear candle violations. When Hush Blackwell asked me a question about a Title IX case that involved residential life, I thought they were talking about a different situation, and I gave a response to that. Based on the report, they were talking about a candle violation, which I have no purview over. That's
So you wouldn't have even touched that? Yes,
No,
Storm. Okay, so what was the next criticism?
I don't know. I would have to go back and look at the report to walk through that.
I mean, people are being disciplined. I think you won't make yourself privy to what they said you might not have done. You know, and I'm just that's my unpaid, unsolicited legal advice. Like seriously, you know.
Yeah.
And those, I have no further questions.
Thank you.
But hopefully, this process is not the process anymore.
No, it's changed.
I would hope so as well. I'm sure that they can see all the flaws in it. Going back to something Senator Mizell said as well. I'm gonna ask Morgan Lamondre if she would come up to the mic that's right here, to the side.
Do I?
Excuse me.
And just let her add. Yes, ma'am. Right there. Yeah. I'm moving.
Senator, are we excused from the table?
No.
He's like, can I go home?
Just or restroom? Can I go to the restroom?
The legal degree is now having to ask, can he go to the restroom? You can go. You work hard.
Okay.
Women, don't try to run away from us. We're waiting.
Ms. Lamondre, would you please introduce yourself for the record? It may not be. Turn it on. What?
Thank you. Morgan Lamondre, I work for STAR, and I guess, Senator Jackson, I was hoping I could explain sort of the process as I knew it representing survivors in the old process and how confusing that was. And I am an attorney that represented a survivor under the new process. I think he said they did it twice. I represented one of those survivors recently. So starting with the old process, and as an attorney, Senator Jackson, it was the most confusing process to ever go through for LSU. I've represented survivors at various other institutions, and LSU had one of the most confusing processes. I did bring it to the attention of someone named Matt Gregory, who I believe was in the position before Jonathan Sanders, and Jenny Stewart before she was Title IX coordinator. And so let me explain how it worked before the Trump era regulations. There would first be a report, and there would be sort of the Title IX coordinator, once there was a coordinator, would look at the report and just determine if there's some sort of suspicion that, yes, this is a Title IX violation. And before the Trump revisions, it could be pretty much anything that would be sexual misconduct under the Student Code of Conduct. But you had PM 73, which was their report on sexual misconduct, like all of their policies. They also had their Student Code of Conduct. So it was like, okay, well, we have these two different like policies, but it was kind of the same thing. But the way it worked is the Title IX coordinator would look at it and be like, yeah, this falls under PM 73. It would be assigned to an investigator. An investigator would typically interview both the person who made the report as well as the person accused. Then the investigator at that point would determine if by a preponderance of the evidence that person was responsible. So in the eyes of most people who go through that, it's like, okay, well, my burden of proof, which is more likely than not, has been met. So my end of the process should be here. That was not the end. What would then happen is that whoever didn't get whatever outcome they wanted, so if it was the person was found responsible, that person could appeal. If the person was found not responsible, the other person could appeal. You could then appeal to the Title IX coordinator. The Title IX coordinator would then say, based on, I think you could only, I don't remember specifically what basis the Title IX coordinator would then get to reverse the appeal. But once that appeal happened, then they would say, okay, well, we're going to send it to the individual campuses. In my experience on the Baton Rouge campus, it would then go to student advocacy and accountability. Well, the student advocacy and accountability person would review the facts, meet once again with the victim and perpetrator, and for me, I'm like, at this point, there's been some sort of finding. They would ask questions of the victims and they would rehash details. I have never personally had a survivor that I represented with Jonathan Sanders, but one of my other attorneys has. They naturally do ask questions, and I think it's because after they ask questions, usually they'll kind of say at that point, okay, well, I think based on this process, I'm going to recommend to the perpetrator, and I'm using that language. They'll say, okay, deferred suspension, so kind of like a probation. You have to take some sort of class that good decision making, you have to get mental health counseling, something along those lines. But if the perpetrator didn't agree with that, then they could appeal to a hearing panel. The hearing panel rehashes all the facts. And
wait, I'm sorry.
Hold on.
How many, before you go to a hearing panel, how many procedures have you gone through?
So you've made a report. You didn't necessarily interview with the Title IX coordinator, but the coordinator reviewed it to see if there's some sort of suspicion.
Right.
So that, I would still call that a process.
Right.
Then it went to the title, whoever was investigating. Until recently, it was what they called volunteers, more voluntold. And it could be the residential life coordinator. It could be...
So no one that was specifically trained to handle this.
Well, and I want to be clear that they'll say that they were trained. They had maybe a training.
So
and
like we take a sexual harassment course for an hour.
It was probably something similar.
Yeah, I don't suspect any of us are ready.
The training would, in my opinion, and I think that there's a vast difference between learning about how to interview victims versus doing real investigations. And I can explain sort of my critique of investigations there too. And it's not just LSU. I want to make that clear.
Right.
I'll tell you listening on your phone.
But so to answer your question, then you've gone to an investigator, then you've gone to the conduct person. So at least sort of 3 processes at that point before the hearing panel.
So at each process, there's one person making a decision.
In each process, yes.
Yeah, because I know, and I've only represented one student at ULM, and it wasn't sexual misconduct. But I know we go from that dinging, and we have to go through a panel after that.
Right.
But you're saying it's 3 different.
That's what was so confusing about it, because I set my...
Yeah, that's not every university. Because I'm telling you, I've gone through it with 2 students from ULM, and your one-person panel is that first tier, and if you don't agree with that decision, you go to a panel. You leave that person and you go straight to a panel.
Right. Well, and I can also get into how they're doing it now, but it's still a confusing process, because then, and I'll just hold on for that. But usually at other universities, it would be that there would be like a probable cause determination, and then you went to a hearing panel. You weren't finding your burden of proof each time. So that's what was, I remember emailing and meeting with them and saying it's not, as an attorney, it doesn't logically make sense that I have to meet my burden of proof so many times. Once I meet it, it should be met, the end. And so what would then happen is almost I've never seen, in my experience, somebody who was accused of sexual assault not appeal to the hearing panel, because what motivation do they really have? Because it's just, if they took that penalty, usually at that point, then they have to do whatever the penalty is. If they go to the hearing panel, it also delays time.
Right.
And so then you have to wait for a hearing panel. Survivors would then go through the hearing panel, and back before, there was no cross-examination. Essentially, you know, the panelists would maybe ask questions. Once there was a finding, and I would say in the cases that we did represent survivors, there were findings of responsibility by those hearing panels.
So, like, let's say, and I'm going to direct this toward Mrs. Sanders because I'm trying to understand this. Sexual assault happens. That person is issued a punishment. I think it's by you, right? The Title IX finds that there is probable cause or justification, and you say you have to move off campus. Let's say that person appeals. Is there a stay?
It's a rehearing of the case, not an appeal, but
No,
to the
a
hearing
rehearing.
panel.
Is there a stay of your decision, and that person gets to stay on campus while they appeal?
Yes.
So we have a sexual assault victim who stays on campus while they have a rehearing.
Per our Code of Student Conduct, unless they're intentionally suspended. We have worked on revisions to our Code of Student Conduct to remove that in our process, and that's not something that's been implemented yet.
Yeah, let me tell you what the court does. The court says that if a person, right, Jason, help me because you know this, right? That if a person is found guilty of something and punishment is implemented, that person also has to request a separate form, which we call a stay, of the punishment while that case goes up for appeal. And then you, at that point, who've heard it, gets an opportunity, or the court or you or whoever, or the appeals committee, gets an opportunity to say whether that person has a stay of the punishment. And what I'm saying here is that, let's say you say, okay, you did something in a dorm against a woman, and you don't ever need to stay on campus again. Well, without that part of the procedure, you could seriously know at that point, this is bad. I don't care how this person appeals, this is bad and they don't need to be here. If you separated those two and made a person not only file a rehearing, but made them file for a stay of your decision, you or the hearing panel that's going to could make the decision on whether that person gets to stay on campus while they're appealing or having a rehearing. I think that's really significant because let's say you've heard it and you say, okay, yeah, you got a right to a rehearing, but we're not letting you stay on campus because the facts don't dictate that we don't move you off campus temporarily. Now, if your rights are restored, we'll save your room and we'll gauge it and all of that, right? Even we'll pick up your costs for staying off campus if you're found to be innocent at a rehearing. But I think it's very important that that person who you have believed to need to live off campus is not allowed to live on campus during a rehearing.
Senator Jackson, unfortunately, in this process, it gets worse. Mm-hmm. Once a hearing panel decision is made, and this was the old process, but unfortunately, I think it still might be the same process for this student code of conduct. I'd have to clarify. But then they could appeal to the dean of students. The dean of students gets to then say, you know, uphold the decision or not. In my experience at STAR, they would uphold the decision. Then the person gets to appeal to the president.
Okay, let's talk about the dean of students process because I'm going to go back and forth. I want to understand this. So you said they're guilty. The panel has said they're guilty. So why does one person get to usurp a panel?
Why does one person get to, what was the last
Usurp
word?
the panel's decision.
Usurp?
Usurp.
Usurp?
Mm-hmm.
Meaning to appeal, while they're appealing, they can remain a
To
student?
basically say, hey, I know the panel made a decision, but I see it a different way. Why does one person get to, and I know this is not your rule, but I'm just putting this on your mind. Think about it, okay? Why does one person get to override a panel? Am I making sense? Like, basically, and I got to go with my career because it's all I know. We're before one judge when we go to district court. Then when we go further, we go to 3 judges. Then if we want to go to the Supreme Court, and we're lucky to get there, we sit with 7 judges making a decision. There's never a point in the legal process, right? Well, do we sit with 7? We sit with 3, I think, right?
3 judges
3.
can overrule a jury.
Right, I understand that because they're judges and they have expertise, and juries
But
are
a
lay
high
people.
burden.
Yeah,
High
with a high
burden to do
burden,
that.
and also juries don't know the law that's being applied. But here, that's what I'm concerned about. You go to one person, then you take that one person to 3, then you go to another person, let's say the dean of biology, unless you're telling me that they're like judges and the dean of biology has expertise in that area, right? You said they can go to the dean of students, right? Dean of students. So the dean of students has training in that area. How many hours does the dean of students have to have training in sexual assault?
I don't know.
Because this person has to be an expert if he can overrule everything, he or she. They have to be an expert if they can overrule a 3-person decision. There has to be some logic of why one person can overrule a panel of 3. And usually with the judges, it's because they have the expertise in law that lay people don't have. We get that. They've trained in law school unless you're going to give lay people the same degree of knowledge as you have in your degree, right? We get that. What I don't get, unless the dean of students has some expertise that we're going to assert today that makes he or she extremely qualified to overrule 3 people, why does it go to the dean of students with no panel? Am I making sense? And maybe the dean of students, can somebody tell me, maybe the dean of students is an expert in sexual assault. Maybe he or she, once hired, has to be trained to become an expert. Is the dean of students an attorney?
Not in my experience from when we represented survivors, no.
You get what I'm saying? Like, that's where I think, and I'm going to say this just in case that's still in place, that's to me a flaw in the process. And I want to make sense. And also, let me tell you what's the biggest flaw. That's when you get cover-ups. And let me tell you why I say that. That's when one person who walks that campus every day can be influenced by others. I thought the point of increasing the number of people who are hearing these cases is to make sure upon review that it's fair and equitable. You know, like when we go from the district court to the circuit court, we get like a 3-judge panel. Because one judge has already made the decision, so now we go to a higher court to see if those 3 judges differ. But you never go back to a 1-judge panel. Because every time the scrutiny overturning a case gets higher. But here it seems like in the tiers that LSU had before you, because I know you're going to fix it, right? You're a decreer. And you guys have a great legal representation. I'm not saying it to be funny. You all have a great legal reputation in this community, and you've been fair and equitable. I've never seen you do anything egregious. That's a wonderful thing that people can say that about your family, right? And the flaw is this, and it's a big flaw, that you can go to one person who overturns 3 people. But we can't say on this mic, on this record, where that one person has any expertise that excels 3 people in a sexual assault, harassment, or rape case. Know what I mean? So that's something I'm going to ask. And I know we asking you to fix a lot of stuff, and you're probably like, I didn't know all this was going to happen when I got this job at LSU. I probably would have stayed in my firm. Seriously, that needs to be fixed. The appeals process needs to be simplified. And there should not be an automatic stay of an execution of a sentence by the person you put in charge while that person appeals. Now, whether we have to, and it's just like anything else that's done in a court system, if the decisions were wrong and the appeal process inures to that person's benefit and that person is found to be innocent, yeah, any financial things that they've occurred for staying off campus or whatever punishment should be restored to them. I don't even mind putting that in the law, right? I don't care if you have to carve out a special process for sexual assault cases. I think you should, right? I really do, because of the preservation of evidence that's needed in these cases. And I can tell you, if you're going through this whole process, and I know I'm rambling, you know I'm about the law, right? You are constantly like losing witnesses. People are getting tired. People are getting fatigued. And the victim finally says, forget it.
Yeah.
Especially in this situation, Senator Jackson, I would say it's exhausting for survivors. They're like, how many more times do I have to get somebody to rehash things, to be questioned? And if you survive the dean of students, you get to go to the president.
Another one-person
So,
panel.
Senator Jackson, what I think would be helpful,
Yeah, help
If
me,
you-
because
if
I'm
you-
rambling now, because it
if
all
you
doesn't
turn
make
to
sense here.
page 126 in this booklet you were given, it's
I'm
right
there.
before section 6. If you look at the left column,
Okay.
the far left column, you'll see below complaint, Title IX coordinator meets with respondent, supportive measures and processes. That's emotional support, LSU Cares, Lighthouse. There's only 4 more boxes: investigation, pre-hearing, hearing, and appeal, and it's over. That's where we are today in how a complaint runs from adjudication through appeal.
So where we are now is,
If you look at investigation, there's only 4 boxes there: investigation, pre-hearing conference, hearing, and appeal.
okay.
That's
So-
it.
So what about, okay, formal complaint is filed, okay? The notice of allegations are sent to the respondent, right? And then Title IX coordinator meets with the respondent, supportive measures and process. Let's talk about Title IX coordinator. Does the Title IX coordinator ever meet with the victim? Because it only says it meets with the respondent.
The supportive measures and process would be for the victim, is my assumption.
Okay,
I
so
don't think
that's
that
where the Title IX coordinator makes a decision or something?
No, the
I
Title
can
IX,
explain what happened recently.
the
if
Title
that
IX
helps.
coordinator doesn't make any decision until the appeal here.
Okay, so an investigation happens, I see it. And there's a pre-hearing conference, that's reasonable, that happens all the time. And then there's a hearing.
Yes,
Who's in that hearing?
it's 2 people plus an administrative law judge.
Okay, so now we've corrected it.
Well,
Okay.
do you have a question first, or?
No, just identify yourself since we're changing over. This is,
Oh, I had introduced
She
myself already.
introduced
I know.
Oh, Morgan Lamondre again.
Okay.
We corrected in the sense that the process of this chart is followed. I mean, I think maybe I was the second hearing this go around. I think because Jonathan was a hearing panel. So I don't know. He was a hearing panel member, and he did find the person responsible and expelled him, which is what I asked for. So that's good.
So
But
Jonathan was a hearing panel person with 2 others?
yes,
Okay, so it was you, administrative law judge, and who else?
it was I think the dean of students,
No.
right? Or
It was,
DeLuca.
2 staff members. It was myself and another staff member from our department were the 2 other folks in addition to the administrative law judge.
So right now, how it stands, and this may be a good process, okay, it's the administrative law judge, yourself, and your staff.
1 staff member, yes.
One staff member, okay. So now we have a panel. That may work.
But it can be it doesn't have to be our staff. It could be other folks too.
Now, how do we determine who goes in that room with enough expertise and experience to hear these cases?
That's why the administrative law judge is a requirement from the Division of Administrative Law.
Okay, so is it a vote of 2 out of 3?
We're reaching consensus, so
Does the majority vote?
however you
So
do that.
basically, those 2 staffers with very little to no experience, if it's see, this is what we're gonna fine tooth it, okay? Fine tune it, I mean. So even though the administrative law judge is there, a majority consensus has to be reached for something to be implemented. So the 2 staffers that are sitting there can basically outweigh the administrative law judge, and I'm fine with that. I'm probably not having a problem with that, but I think we need to define what criteria has to be met for a staffer to sit on that panel. I think that, and so I want to work with you on that. I think it's a good process, but I think what's missing is because, and I get the majority, it's a serious thing. I think we need to define what training a staffer has had to have to sit on that panel. And I think those need to be designated staffers, like we do continuing legal education, that continue every year to be trained in this area. That would be my strong suggestion. And you may have 6 to 10 staffers per campus that are trained in that area, right? But I mean, I'm a biology teacher. If you can pick any old staffer, right? I'm a biology teacher, don't know anything about sexual assault, so I can get picked to sit on that panel. We still have a flawed process because the administrative law judge shouldn't be the one with all of the information. Because
excuse me, I'm sorry for interrupting, but it's not necessarily the administrative law judge that has enough expertise, in my opinion, to actually be able to hear a sexual assault case based on what happened in the hearing.
And I get that, but I'll say this, and I'm gonna be honest. These elected judges, some of them never tried a sexual assault case in their life and never represented anyone. So that's what you get with every judge in this state, because they're not, and I hate to say it, they're not fact-specific, case-specific, unless you're in family law and they become experts at it. But I know some family law judges never practiced family law till they got to the court. And I'm talking about the real court. And so I'm getting that. I hear it. But I think we could fix that. I think that, because I want to not take this for granted, I think that may, and I don't know if we even have legislation left, I know I don't, may require legislation that says the administrative law judges that sit through these processes have to have the same training to be eligible to sit through the processes. And I think that fixes. I think also, Jason, we need to say, Attorney DeQueer, that we need to say, I called you Jason, I know, don't be mad at me, okay? That's what happens when all your brothers are attorneys. I think we need to say that these staffers who avail themselves to sit on this must have this specific training, and it should be offered every year.
Which I think that, as far as my experience, hearing panel members typically are trained. They're trained about trauma, they're trained about how to ask questions. Sometimes they don't necessarily ask them in the most trauma-informed way. There's definitely more training on that. My concern as an attorney who went through the most recent process is the understanding of how to investigate correctly, how to analyze evidence, and how to present, and I mean, I think my client, would give permission, but obviously I know I don't have it with me, but I truly believe that had I not been there, there would have been a misunderstanding of the facts, because the investigation was very much not done in a way that I believe outlined the sexual assault. And what ended up happening is, I think I was able, because of the cross-examination, which a lot of people do not agree with, those new rule changes, and it's weird as a victim advocate to actually be a proponent of that. I'm a proponent of it based on what I saw in what I consider a poor investigation. I believe I was able to recover and show that this was a serial perpetrator who needed to be expelled, and I believe we're able to do that. But I don't know if he could say it, but I believe that there are some deficiencies in how evidence is outlined.
Okay, so let's talk about the investigation. Who conducts the investigation in this new chart?
That would be the Title IX investigator.
So the Title IX investigator will never sit on the hearing, right? Because the person that's conducting investigation should not ever sit as a judge.
They shouldn't be a hearing panelist, no.
Okay.
They were like a witness in this proceeding, because they were asked to present their findings, and then we were able to cross-examine. When I say we, the respondent, the perpetrator, he had an advisor. I was also able to cross-examine the hearing panelist. What was weird in that situation is that the hearing panelist started questions first, and I was like dying, because I'm like, the way the investigation was outlined, they were having trouble understanding why certain things were not done, and I could see where the deficiencies were.
Yeah, I get it. I've taken enough time, and I can get very lengthy, because this is but I think it's worth it so that people have a fair chance to have their cases litigated. I think we need to I like the new procedure, but I've made my recommendations on who should actually be sitting on panels, and that there should be requirements put in place, and that the administrative law judges, which we'll probably have to do administratively here because they're state employees, that they should have some type of training in this area before sitting on those cases, okay? I would say that this procedure needs to be put in place, Attorney DeQuitta, go a little bit more judicially, where the panel is not asking questions first. I understand that first witness is necessary because they've investigated it, but I think both the plaintiff and defendant in that case, I know you guys call it something else, should have a chance to cross-examine, to question, and then the panel questions should come. But I'm really concerned that we need to put it in more of a format that gives everyone, because that may be the only court that student sees, or the only form of justice that person has had their day before that panel, that panel is well informed of the law, of procedure, and evidence. And however we need to get there, and I'm sure you know how. I can't suggest everything to you, but we need to get there. And we need to make sure those 3 people that are sitting there are able to properly digest and hear a case, because what we may have is just 3 people sitting there, an administrative law judge telling them how to rule.
And Senator Jackson, one of the things though too that I do have concerns about, because with the new regulations, they make it to where Title IX is very specific. Title IX violations have to deal with whether it's on campus or it's a school-sponsored event. My fear is that if it doesn't fall into that, the default is still that old process. Is that correct? That is correct, right? Correct. So a student could file what would be a sexual misconduct complaint under the Student Code of Conduct because it occurred off campus, has nothing to do with Title IX, but now they have to go through that old process that I explained to you. I'm pretty sure it's still the same process.
If it's a school event, though, is included, right? Let's
School
say
events, yes.
So
yes.
let's say we're playing as a Superdome, it should be included.
And one of the things, and Dr. Cassidy is here, is I believe the Office of Civil Rights in Title IX is going to handle all allegations of sexual misconduct.
I think that's what we need to do. I mean, we need a streamlined process.
I think that was the intent of creating that office. Although they wouldn't be Title IX, they would still, if it's sexual misconduct between students or involving students, it would go through that process. Obviously, there would be no jurisdiction between non-students.
But if it's a student, even if it happened off campus between students, it will come to you, right?
I think the intent is to go through that process.
So let's say we're traveling to a game away. That would still be
Title IX.
That would still be Title IX
because it's school-sponsored events.
If it's a school game, yes.
Okay, so I'm good with that. So I think, we just, look, I've given my suggestion. I'm not long-winded, guys, but this has probably been something that's like an eye-opener. How many doors have been left open and windows for people to creep out of and get away with things? Not that was your intention, but I think it's just a process. I think now cleaning up, I would like to see us become a model for other states. And when other schools are looking for processes that work and procedures that are in place that work, just like we were on the forefront of the USA Today for something bad, I would like to see 6 months to a year from now, USA Today, that we did good. And that we corrected this, and that there is a fair judicial process for these complaints going forward. And I know I've made a lot of suggestions. You may not take them all, but there are still some flaws in this process, right?
Yeah.
And we need to get to the point where there are no flaws in this process. Nothing's perfect, but the process we set up can be set up to work. And that's my strong suggestion. Training for anyone that's sitting on that panel. I don't want to go get someone that teaches chemistry to come in and decide a sexual harassment case. And I'm not saying that they're not intelligent enough, because juries decide them. But what I'm saying is they need a little bit of training, because I think that you lose the degree of just, when you're on a campus, right, that students should feel more protected than when they're on the street. And so I don't think it hurts that if we're going to, and I think that when the same people sit, it gives them a recurrence of what's happening. Also, it gives them more knowledge, right? And they know how to handle things better. But I don't want people, if my daughter or my niece had been sexually assaulted, because I don't have a daughter, but she spends my money like she is, right? If she had been sexually assaulted, I would not want her to go through a panel of 3 people that had no knowledge of what happens, the evidence, how to dissect it, how to digest it, and how to make a decision. And so and I think LSU has a chance to become a model at this, so other universities throughout our system and throughout the country can pick up on how do we deal with a sexual assault victim.
Thank you, Senator Jackson. And I know that I saw Winston taking a lot of notes. Attorney DeQuitt taking a lot of notes. So I assume that these will be some things that they look at, and I'm going to ask our board of supervisors as well, after hearing all of this, some of the things, suggestions, and recommendations they'll take up. Okay, this is what I want to say before I take our next legislators. It is about 6:30. My goal was to try to at least have our committee hearing over by 5, so we definitely have blew that. I would like for us to try to kind of bring in and horn the meeting in, if we can, at all possible, to some degree. We have Marilyn Villabas. Am I close? From NCSL, who has traveled, and I certainly want to make sure that she's able to speak, because I know she's heard a lot today, but I'm sure she has a lot of great information to give us. We didn't hear from Scott Woodard, and we need to hear from him, and Jason Drawdy for sure, in terms of his role. And so I don't want to neglect allowing anyone to speak, but I am trying to rein the meeting in to some degree, and I know that we're going to have another hearing. I believe that we're going to have another hearing, because we need to have another hearing. Yeah, one. Okay, and then we have 2 of your colleagues on the line. Okay.
Just to be clear, this process is LSU's process, or is this something that the federal government has laid out under Title IX? This process that we've been talking about all this time.
The process on page 126.
126, that's what I'm looking at.
Is our process based upon the federal government requirements in Title IX.
Okay, but it could be tweaked as per the things that we've talked about a little bit, right?
Yes, the things such as specific training for the officers in the hearing officer box, that's easy to do.
Okay.
You know, those types of things. The federal government mandates certain notices and certain cross-examination and evidentiary rights for the parties involved, and we account for those within the hearing procedure.
Okay, that's good. So the things that we've recommended could be incorporated into this.
Those would not be affected.
I just wanted to be clear on that. Thank you so much.
Thank you, Representative Edmondson. Representative Freeman and Landry. Representative Freeman first.
Thank you, Madam Chair. I'm actually just getting out of my car. I had to leave to get back to New Orleans, but appreciate you. Randy and I have been listening in most of the way. And I have 2 quick questions I think they would be for Mr. Secure. And the first one is, how much money is LSU investing in the action plan per student? I know that there's 35,000 students at LSU. So I'm wondering, what is the investment going to be in this new plan, and what is the amount suggested to fully fund such a plan? That's my first question.
I don't have an amount per student, but at the last hearing, the president estimated it would take probably $1 million plus a little bit to fully staff the Office of Civil Rights in Title IX.
Okay, so and again, I just want to know for the record, is that money that you all are pulling out of the current budget that you have?
Yes, that's money we're going to have to reallocate within our current budget.
Okay. My other question is, when I was hearing Senator Jackson talk about student affairs, athletes, it came to my mind that student affairs has no. And I want, maybe this is for Mr. Sanders. Does student affairs have any purview over student athletes playing in a game?
No. That would be athletics or the team or whoever that would be. Okay. Unless they were suspended or expelled from the institution, then they are no longer students, so that by nature would prevent them from playing in games.
So, Mr. Sanders, you have no contact or coordination with coaches as that being part of a punishment?
No, I don't.
Okay, that's a mistake in my mind. I mean, they're students, and they are student affairs students, and they're also student athletes. So I'd like to know more, and this is probably more for Mr. DeCure. I'd like to know more about how that can be fixed, because it seems to me that student affairs should have some coordination with coaches. in the new plan because they're students and they're athletes. So, and then my other question for Mr. Sanders is, it seems like when you look at the Title IX cases that came under you, and I guess these are mostly under the old system, and I'm not going to rehash all the different things that I've read, but it seems like about, let me see, I'm looking at my notes because they're on my phone, so hang on one second. I think it's about for the violations, about 3 out of every 5 students with a Title IX offense continued their coursework without interruption. And so I really would like for Mr. Sanders to speak to how that happened, because some of the cases that I read about in Hush Blackwell, it was very unnerving to these victims to, you know, have anxiety attacks and different things happen when they had to see these people in classes. So I'm trying to figure out why 3 out of 5 students were, you know, continuing as normal. And I do understand, I'm not an attorney, and I do understand there's due process, but what is in the new plan that helps address that for the victims and their rights?
So if I can speak to the data specifically, I shared earlier that shared data with USA Today, well, the university shared on behalf, and he kind of picked what he wanted to narrate in that data. The year before I got into my role, 15% of the students who went through a Title IX process were suspended or expelled. My first 2 years in my role, that increased to 27%. The last 2 years was 69%. Overall, during the 4 years I was there, it's 41%, which is much higher than the 15% the year before I arrived in my role. I think we have navigated, I think we have gravitated towards to be more punitive in that way. I look forward to this committee being formed and really the students, faculty and staff, and us a community deciding what do we think the appropriate outcome is based on certain specific pieces. Another issue in our old Code of Student Conduct is actually our current Code of Student Conduct, but we worked on revisions this past fall before the Hush Blackwell report because we knew we wanted to make it more in line with Title IX, the new Title IX regulations, is actually parse out sexual misconduct. Sexual misconduct is a very broad term. In our definition, it's actually, it's anything from non-consensual touching to non-consensual penetration. It runs the gamut. We've actually had hearing panelists struggle finding a student responsible for sexual misconduct because it was on the low end of the spectrum and not on the upper end. Because when they hear that term, they think about non-consensual penetration or some other act that may fall into that piece. In our new code, we're moving forward with, and of course we're taking all this information to look at that, and this is a committee of faculty, staff, and students, and then obviously the new folks will be a part of this process, is actually to parse out some of those violations, specifically the ones that are listed in Title IX. So the Title IX violations match the actual Code of Student Conduct violations too, when it's in regards to sexual misconduct or sexual violence.
Okay, you kind of answered my question, but I think what I'm trying to say is, why did you pick the lightest punishment 60% of the time, essentially? And so if you pick the lightest punishment the majority of the time, is that because you're telling me that these cases were less severe? Is that what I'm hearing you say?
If someone received a less severe outcome, it's because I believe that the act was less severe than someone who received a more punitive outcome.
And in this new plan that Mr. DeCure and President Galligan and the board chairs have mentioned to us, were victims involved in the creation of what's the less severe and what's the more severe? Because, as a victim friend, I should say, I'm not a victim myself, but I have friends who've been in victim situations. What was their say in how that happened? Does that all run through the federal regulations?
No,
or was it something that you all decided, like, okay, well, this is the most severe, this is the least severe, this is
The penalties are in the process of revision under the new Office of Civil Rights and Title IX. They're not revised. I will tell you, the new Title IX policy that began in August of 2020 was shared campus-wide and specifically targeted to certain women's groups on campuses so we could get feedback, which is precisely how we got the flow chart. The flow chart was feedback from a group that reviewed the policy and said, it's 28 pages. You got to have a way for students to understand this, and so, yes, we will share it with the students for feedback, but it's going to be put together. It's not put together.
Okay, I understand it's in the process, but okay. So then my other question for LSU, and I think this is a bigger, more global question that needs to be considered, and I don't necessarily expect an answer. We have a lot of kids from around the state who are ending up at LSU, and this, for some of these students, it's their very first time out of their small towns. So what is LSU going to do to be a leader, and this could be for the Board of Regents, what are you all going to do as leaders, LSU being the lead because of the situations that we're learning about publicly? What are you going to do to help educate these high school and middle school students early enough so when they get to LSU, this isn't the first time they're hearing this? Because in my mind, as a mom of 4 kids, these problems are starting long before a student steps onto campus. So what can LSU to help do for the kids throughout our state before they get to LSU? And can that be part of the plan? Maybe that's the question. Sorry, that was a little long-winded.
I'm rarely at a loss for words, but if I'm hearing you, you're asking, can LSU reach down into high school to try to provide some proactive education before they get to college?
Yeah, I do think that's part of the problem that we're having here, is because
I agree with you on the problem.
You could build the best plan in the world that everybody signs off on, and all the attorneys like Katrina and the advocates like Morgan can tell me this works. But if you get students coming in who haven't been educated on this before they get to college, how can we really help them?
I agree with you on the problem. As the general counsel, how to reach down into the K through 12 system is probably not my forte. It needs to happen, but I can't say that I have an idea sitting here at this table on how to make that happen.
Okay. And I understand that, Ms. Secura. I do understand that. My reason for asking that question is we do educate a lot of teachers at LSU and at our other systems throughout the state. So I think it's really essential that we look beyond just LSU and we look at how we're educating our kids before they get there. So that's why I'm asking that. And so if there's any piece of that plan that can involve that, even if it's just recommendations, I think it's really important. So thank you, Madam Chair. I don't have any other questions. I appreciate you letting me ask questions on the road.
Thank you, Representative Freeman. I believe there's a follow-up to your comments. Introduce yourself, please.
Hello, my name is Rachel Hebert. I'm the president and CEO of STAR. I'm glad that the caller actually brought up this comment. So at STAR, we're working closely with LSU to fix these Title IX issues. But the issue is happening before students get to LSU. And so I do want to bring attention to sex education in high schools. That's actually something that's come before the state legislature for the past decade by former Representative Pat Smith, and that has not been supported by this legislature. And I think when we're talking about sexual violence prevention, it has to start with comprehensive sex education in schools. And LSU has done a lot wrong, and we can all look at the report and we can all sit here and talk about it. But if we're really talking about prevention, it's not looking at these processes. It's really looking at how students are coming to LSU and what education they've gotten before that. And so I just did want to bring that attention as something else the state legislature can do to help with this prevention focus. Because really, once students are at LSU, if you look at the statistics of sexual assaults that are happening, 50% of sexual assaults happening on campus happen within the first 4 months of the semester. And we know that freshmen are most vulnerable. So by the time they get to LSU, they're already at risk, and they haven't gotten that education in high school. So I don't want to be very long-winded, but I just want to have the opportunity to say that, because I think it is something that as a state we have to commit to when we're talking about prevention. Thank you.
Thank you. Thank you for that testimony. Thank you for sharing that with us. That's very insightful, especially to know that sexual assault actually happens within the first 4 months of them actually starting school. That's very interesting.
Yeah.
Okay, thank you so much.
Thank you.